Welcome to the deep dive. Today we're getting in something really interesting. Affirmative defenses in contract law. We're assuming, that offer, acceptance, consideration, all that's established, a contract exists.
Exactly. So the plaintiff's done their job, but now the defendant steps up. Our mission today is to look at those extra facts the defendant can bring in to basically say, yes, we had a deal, but it's unenforceable. We're past formation now.
Right, we're looking at why the law might refuse to enforce a perfectly formed promise. And we're tackling this by looking at two main categories, right?
That's the plan. First, we'll look at problems with the contract's subject matter itself, think illegality, specifically restraints on trade. Then we'll shift to defenses based on the parties, focusing on incapacity minors being the classic example.
Okay, that structure makes sense. It highlights these big policy clashes. Freedom to contract versus, say, open markets. Or protecting vulnerable people versus just enforcing deals.
Precisely. And we'll start right where those policies often collide head-on.
Great. Let's jump into that first collision. Contracts in restraint of trade. You've got freedom of contract pushing one way and the need for market competition pushing the other. When does a deal limiting trade become, well, unenforceable?
It comes down to reasonableness. I mean, the law is pretty clear that contracts mainly designed to kill competition, like straight-up price-fixing deals or agreements carving up territories, those are just void, often illegal even.
Okay, so the obvious bad stuff is out.
Right. But you can have agreements that limit competition legally, if they're secondary or ancillary, that's the legal term, to a contract with a legitimate main purpose. Think selling a business or an employment contract.
Got it. The non-compete clause is the classic example there. So how do courts figure out if that clause is okay, a legitimate tool, or if it goes too far and becomes an unreasonable restraint? What's the test?
They're only okay if they impose reasonable restraints that are narrowly tailored. They have to serve the legitimate purpose of the main deal without going overboard. And there's a specific four-part analysis you have to run through.
Okay, lay it out for us.
1. Is the covenant ancillary to a real legitimate transaction? 2. Is the geographic scope reasonable? 3. Is the duration reasonable? And 4. Is it narrowly tailored to protect only the legitimate interest, nothing more?
4 clear elements. Okay, that's the framework. Let's apply it. How about a case where the court actually said, yep, this restriction is reasonable. Let's analyze Fine Foods, Inc. v. Dahlin. First, what are the legally dispositive facts?
Okay, so you have Dahlin. He sells his restaurant in Brattleboro, Vermont to Fine Foods.
Right.
Part of the deal, a specific clause, says he won't engage in the restaurant business for 5 years and within 25 miles of Brattleboro.
5 years, 25 miles. Okay.
But then, just a few months down the line, he starts working as a maitre d' at another restaurant right there in Brattleboro.
Okay, so he breached the clause. What was the core legal issue the court had to decide?
The question was basically, was that restriction fair? Was the 5 years and the 25 miles too much? Did it unreasonably stop Dahlin from working? Especially when weighed against Fine Foods' right to protect the business goodwill they just paid for.
Makes sense. What rule of law did the court apply here? Can you state the full rule and break down its testable elements again?
Sure. The court applied the rule that these covenants not to compete have to be reasonable and narrowly tailored to the purpose of the main deal. And the elements again are 1. Ancillary to a legitimate transaction. 2. Reasonable geographic scope. 3. Reasonable duration. And 4. Narrowly tailored.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the ancillary purpose?
Well, the court looked at the main transaction, the sale of the business itself, including its reputation, its customer base, the goodwill. That was clearly legitimate.
Okay.
So the covenant wasn't the main point. It was just secondary ancillary. It was there purely to protect what the buyer had bought. So element 1, check, met.
Understood. So the purpose was okay. Now what about the limits? Let's take the second element, reasonable geographic scope, that 25-mile radius.
The court reasoned that the restaurant's goodwill was pretty local to Brattleboro and the nearby area. So 25 miles seemed reasonable to protect that specific asset.
Right.
And they pointed out Dahlin could still work in the restaurant biz just outside that 25-mile circle. It wasn't a total ban. So element 2, met.
Okay. And the third element, reasonable duration, 5 years. How did they justify that?
They saw 5 years as needed for the buyer, Fine Foods, to really establish itself, solidify those customer relationships they bought without Dahlin immediately competing. It felt proportional to the business being sold. So element 3, also met.
All right. And this was tied to a business sale, not just employment. How did that impact the fourth element, narrow tailoring?
Since the whole point was protecting the goodwill Fine Foods bought, the restriction was seen as directly tied to that. It only stopped him from competing in the restaurant business, which was exactly what was sold. So, narrowly tailored. Yes. Element 4, met.
And after analyzing all the elements, finding they were all met, what was the court's final conclusion?
The court enforced the covenant. They found the restrictions reasonable and specifically tailored to protecting the value of the business sold. It shows courts give more leeway when a non-compete is part of selling a business.
Okay, so that one was enforced. Now, this is where it gets really instructive, right? Let's look at the flip side, a case where the restriction failed. Valley Medical Specialists v. Farber. Why did this one fall apart? What were the key facts here?
Totally different context. This was an employment agreement. A medical practice hired a doctor, a pulmonologist that's a lung specialist.
Okay.
The contract had a non-compete. It said after leaving, the doctor couldn't practice medicine within 5 miles of any of the employer's locations for 3 years.
Any location, 3 years, 5 miles. Got it. And what was the core legal issue this time?
It was whether that restriction, 3 years, 5 miles, was reasonable, especially for a doctor. You have to consider the public interest here, right? Access to specialized medical care. Was the restriction too broad given that?
Right. The public policy angle seems much stronger here. What rule of law did the court apply? Same one.
Exactly the same rule. The restriction can't be greater than needed to protect the employer's legitimate interests. And you check the same 4 elements: ancillary, reasonable scope, reasonable duration, narrow tailoring.
Okay, let's do the elemental analysis. The court agreed the employer had some legitimate interests, like protecting patient relationships. But how did they view the third element, reasonable duration, the 3 years?
They looked at the employer's actual need. Was it really just time to hire a replacement doctor and let them build relationships?
Makes sense.
For a pulmonologist, they noted, patients usually only need contact maybe every 6 months. So 3 years, way too long.
Yeah.
The court felt 6 months would have been plenty to protect the employer's interest, so duration was unreasonable.
3 years down to 6 months, that's a big difference. Okay, duration was out. What about narrow tailoring, the fourth element? Were there other problems besides the time?
Oh yeah, big problems. First, the restriction banned practicing all medicine, not just pulmonology, which was a specialty. That was too broad.
Ah, I see.
And second, this is critical.
Mm.
It had no exception for emergency medical care. Imagine him being the only doctor nearby in an emergency, but contractually banned from helping.
Wow. Yeah, that's bad.
Exactly. The court hammered on that. The public's interest in having doctors available, especially specialists, and the sensitive nature of the doctor-patient relationship, these factors weighed heavily against enforcing such a broad restriction.
So the lack of narrow tailoring, combined with the public interest, was key. What was the court's final conclusion then?
They held the restriction was unreasonable and flat-out unenforceable. The lack of narrow tailoring, especially considering the strong public policy around medical care, doomed it.
So these cases show how fact-specific this is. Now, if a court finds a covenant unreasonable, like in Valley Medical, do they just scrap the whole non-compete? Or can they, edit it?
Good question. Courts actually have a few options, and there's some debate about the best policy. One option is just to strike the entire clause that's called severance. Poof, it's gone.
Okay.
Another approach is the blue pencil rule. Imagine the contract says, compete in Columbus or elsewhere in Franklin County. If elsewhere in Franklin County is too broad, the court can metaphorically take a blue pencil and just cross out those words, leaving the reasonable part, compete in Columbus, intact.
Oh, surgical removal.
Exactly. But there's a catch, a policy concern. If courts routinely blue pencil, does that incentivize employers to draft overly broad clauses in the first place, hoping the court will just trim them down later? It's a balancing act.
Right, a potential gamble for the drafter. Okay, let's pivot sharply now. We've covered illegality based on subject matter. Let's talk about defenses based on the party's status, specifically minors. What's the basic rule when an adult makes a contract with someone under 18?
It's all about protecting the minor. The fundamental rule is that contracts made by minors are voidable at the minor's option. The minor can choose to get out of the deal, but the adult party is stuck.
Voidable by the minor only.
Yes. The adult deals with a minor totally at their own risk. That's why we have that Latin phrase, caveat venditor, let the seller beware. The risk is squarely on the adult.
Okay, caveat venditor. Now, let's use a hypothetical to really test this protection. It's a bit visceral. Imagine Bart, he's 17. He buys a used car from a dealership for $8,000 cash.
Okay.
Just before he turns 18, he decides, I don't want this car anymore. He wants to disaffirm the contract. But here's the twist. Last month, he got into a terrible accident. The car is basically scrap metal, a crumpled pile of metal, plastic, wire, and glass. Let's analyze that. First, what are the essential facts?
All right, we have a minor, Bart, 17. He contracts to buy a car for $8,000. Before he reaches the age of majority, 18, he disaffirms, wants out. Crucially, the car, the subject of the contract, is now practically worthless due to his, well, use or accident.
Exactly. So what's the core legal issue here? It's really about the dealer's $8,000, isn't it?
Yes. The issue is, when a minor disaffirms, are they liable to the adult for the loss in value, the depreciation, or even the total destruction of the property that happened while they had it? Does Bart owe anything back for wrecking the car?
What's the rule of law that dictates what Bart has to do when he disaffirms?
The traditional rule, and still a majority view, is that the minor only has to return the consideration that remains in their possession. It's about restitution of the benefit remaining. The policy is crystal clear: protect the minor, even if the adult suffers a significant loss.
Okay, only return what remains. Now for the elemental analysis. How does the court apply that requirement, return the benefit remaining in his hands, to Bart's situation with the wrecked car?
Well, what physically remains? The crumpled car. So Bart has to return that pile of scrap metal to the dealer. That's the benefit remaining.
Just the wreckage.
It's the wreckage. The crucial part of the analysis is that the minor is not generally held responsible for the lost value. Wear and tear, damage, even total destruction before disaffirmance. That loss falls on the adult. The law doesn't require the minor to make the adult whole.
So what's the final conclusion regarding the $8,000 Bart paid and the worthless car?
The inescapable conclusion under the majority rule is that the adult dealer bears the entire risk of the car being destroyed. Bart gets his full $8,000 back upon returning the wreckage. The dealer is out the value of the car. That's the stark reality of caveat vendor when dealing with minors.
Wow, that is a very strong protection for the minor indeed. Harsh for the dealer, but clear. Okay, we've covered defenses based on the contract's purpose, illegality, and the party's status incapacity. Let's synthesize. For you, the listener, maybe prepping for an exam or analyzing a real dispute, what's the actionable step-by-step diagnostic checklist to run through?
Okay, this is crucial for issue spotting and structuring your analysis. When you suspect an affirmative defense might apply, here's a checklist. First, check for illegality. Subject matter. Does the deal violate a law, like a licensing statute? Or is it an unreasonable restraint of trade? If you see a non-compete clause, immediately run the four-element test. Is it ancillary? Is the scope reasonable? Duration reasonable? Is it narrowly tailored? And always ask, what's the public policy impact here?
Okay, illegality first. Then what?
Second, check for incapacity, party status. Is one party a minor or mentally incompetent? If yes, the contract is likely voidable by them. Now, if it's a minor, ask another question immediately. Was the contract for a necessity, things like basic food, shelter, essential clothing, maybe medical care?
Ah, the necessities exception.
Right, because if it's for a necessity, the minor might still have to pay something, but usually just restitution for the reasonable value of what they actually receive, not necessarily the contract price.
Got it. So check illegality, check incapacity and necessities. What's step 3?
Third, determine the effect and remedy. Figure out if the problem makes the contract totally void, meaning it never legally existed, can't be fixed, or just voidable, meaning the disadvantaged party can choose to enforce it or cancel it. If there's an illegal part, can it be severed or blue-penciled to save the rest of the deal? And finally, figure out restitution. Who has to return what? Especially, like with Bart, who bears the risk if the property was damaged or destroyed?
That's an incredibly helpful framework. Illegality, incapacity, effect, remedy. Perfect. Now, speaking of that strong protection for minors, if Bart isn't liable for wrecking the car, it makes me think about something else. What about parents signing liability waivers for their kids? You know, for risky stuff like trampoline parks or ski trips. What does the minor rule suggest about those waivers?
Ah, that's a fantastic and provocative question to end on. It really highlights the limits of trying to contract around this protective policy. The general rule, quite startling to many parents, is that in most states, a parent or guardian cannot validly waive their child's future right to sue for injuries caused by someone else's negligence, unless maybe they get specific court approval.
So the parent's signature doesn't bind the child.
Often, no. The law prioritizes the child's right to seek compensation for injury so highly that even the parent can't sign that right away beforehand. So the child, upon reaching adulthood or sometimes even before through a guardian, could potentially still sue that trampoline park or ski resort, even if mom or dad signed a waiver. It really shows how deep the policy of protecting minors runs it, can even override a parent's attempt to contract on their behalf.